Well, good afternoon. My name is Nathan Green. Um, this is transition planning for business owners. Before we get too far into the subject matter of it, I'd like to, kind of give the standard issue legal disclaimer here. This isn't legal advice. This is for information purposes only. Don't take any action and don't fail to take any action because something I've said here. Consult your lawyers. Every transaction is going to have its own little, twists and turns, and they're going to be very small and insignificant to, the average person, and they're going to be very, very, very important for the lawyers involved in it. So, please consult lawyers if you're thinking of engaging in something like this. And if I can just get my presentation to start going. Okay. A little bit about me. I am a corporate lawyer with Hutchinson, Thompson, Henderson, and Mott. The firm has been in the Milton area for 99 years. We're coming up on our centennial. For becoming a lawyer, I got a degree in aerospace engineering out of Ryerson, and then I went and got my law degree at Queen's University. I've been with Hutchinson Thompson since 2013. I've been practicing law since 2011. I'm a local of the area. I was raised in Oakville, was very active with Air Cadets there in my teen years. Ryerson in Toronto, after that Queens, and then back to the area. I did my articles in Hamilton. But I've always been, in this neck of the woods. So I'm going to be talking about 7 broad areas today. Objectives, consultations with lawyers and accountants, preparing the company for the transaction, some transaction-specific steps, various other matters related to the transaction, common problems that these kinds of things run into, and some of the timing issues. And timing issues do kind of fall under common problems, but they're very significant to this kind of thing. And right from the get-go, and I'm going to emphasize this point as we go through, timing is important with these transactions, and the sooner you involve lawyers and accountants, and the sooner you start thinking about these kinds of things, the better off it's going to go and the smoother it's going to go. So, objectives. Obviously, with transition planning, what we're talking about is, you've got a successful business, it's going well, and you're saying, you know what, I want to start stepping back from it. And I don't just want to close up shop. Like, this isn't, how do I get out of my lease and all of this? No, we want the business to survive. You're stepping back. There are a few common kinds of strategies that people have for this. They start thinking, well, okay, am I going to sell the business to my kids or another family member of mine? Do I have a brother or sister who's really actively involved with the business and they want to take over, or they're very interested and they'd like to take over? Another common objective is people say, well, I've got this key employee who's been with me for 15, 20 years. They know the business inside out, and they want to take it over when I retire. And we've had some conversations about this. They've expressed an interest, whatever it is. Another common way to do it is people say, well, you know what, there's a lot of value in this business and I don't have an immediate family member who wants to take it over, or I do, but they're not willing to pay me and I need the money. So I want to find a third party to buy it. So we're going to, sell it to an arm's length third party. They don't know anything about the business today, but, they're going to get themselves into a position where they're going to want to buy it within, some period of time. Another common thing people do, gift to kids. This is often when the business has been, quite successful. The parents have taken the money out that they need for their retirement, and they're saying to themselves, well, you know what, we're going to be leaving it all to the kids anyways, and they've got an interest in continuing it. Let's just gift it over to them as best we can. And then also there are custom arrangements. There are situations where parents pass on the equity of the company to the kids, but they hold on to control themselves. They say, you know what, I've made my money, but I'd like the kids to reap the future benefits. However, they're not ready for control yet. I'm still going to be running things day to day. I've seen people who want to gift their shares in the company to employees and said, look, I've done very well for myself, and I owe it all to these employees. They've been fantastic. I think it's time, they took over, and I'm not terribly interested in making any money from the deal. So it's very important that you, before you, kind of get into it with the lawyers and accountants, have an idea in your mind of what it is you'd like to do here. And while these are the most common things, there are a lot of other strategies, and everyone, is kind of unique with what it is they'd like to accomplish in a perfect world. And I generally tell people, don't worry about the practicalities of it at this stage. Before you see, a lawyer or accountant, have an idea in your head of, gee, what is it that you'd like to do? Because that's going to guide the discussions with the lawyers and accountants. Which brings us to the second step, consulting with the lawyers and accountants. Now, before you actually do anything about your objectives, you've just got them in your head, you want to consult with lawyers and accountants. It's important that both are involved here. And I'd like to emphasize here, an accountant is not just the bookkeeper, and an accountant is not just necessarily the person who files your tax returns every year and you see for 10 minutes when you go in and sign your documents. You want someone who's giving you advice, getting to know your business, getting to know you, getting to know your financial status overall, getting to know what you want and how you think, and that's true of both your accountant and your lawyer. But both need to be involved here. The lawyers are going to hear your objective, and they're going to start thinking to themselves, okay, well, what are the typical strategies to accomplish this, and what are the typical, consequences and side effects? Is passing on the company to your kids going to trigger a disposition and trigger taxes that we're going to have to deal with? So lawyers start thinking about those things. The accountants start thinking about those things too. They're a little more focused on the tax side. The lawyers are a little more focused on, the practicalities of it. But the goal here is, after a couple of conversations with the lawyers and accountants, we've moved from a broad objective to a much more practical plan of, okay, here's the things we need to do to make this happen. Here's an idea of the timelines we're looking at for these different steps. And, here are the things that the lawyers and accountants are going to need to do, such as planning memos and documentation. And here are the things the business owner is going to need to do, such as, finding a third-party buyer, having conversations with the kids to see, yes, do they actually want to take over the business, those kinds of things. Step 3 is a pre-transaction step, preparing the company for the transaction. Now, this is something that companies where they're, taking care of their annual minute book updates, they're going to see their lawyer once a year and just, making sure everything's clear. They're going to see their accountant every year, and they're listening and following their advice. They're going to be in a better position in this step than someone who hasn't been doing those things. However, it's very, very common that people don't have their minute books updated. They've fallen offside some of the rules for the lifetime capital gains exemption, and this is the step where we start to clean up those things. This is also going to have to be done as part of the transaction, but it can be done in advance, and really should be done in advance. If for no other reason, then the bills for doing all of this stuff are proper corporate bills, and you want the company to get an invoice and pay it before you start thinking too much about bringing in like a third-party buyer or someone like that who's going to start scrutinizing things and saying, well, wait a second, this is a transaction expense. You should be paying this personally. Get it into the company beforehand when you can. So document key agreements. If you're looking to sell to a third party, one of the first questions they're going to have is, hey, do you have contracts in place with the key customers, the key suppliers? Am I stepping into some handshake deals here, or am I stepping into binding contracts that have been working for some time? If we don't have those things, we might have to do those things. Update corporate records. Annual minute book updates are often neglected. I keep beating the drum on it. I think they're more important than some other lawyers, but if you need a signature from someone approving a director's resolution, approving a shareholder's resolution, approving some transaction that happened 5 years ago, and you try to get that after the transaction is done, well, that's not going to be so easy to do. Get it in advance, get it when it's no big deal, keep it up to date, make everything nice and easy. Sometimes for some of these transactions, articles of amendment to the incorporation are going to be needed. Not a huge deal, but there's a timing issue there. Those get stamped by the ministry, and there's a specific date on it. And if you want to have your transaction complete February 1st, and you don't have your articles done February 1st, that's just it. Finally, purification and accounting steps. In order to qualify for the lifetime capital gains exemption, there are certain accounting requirements, and often small businesses can find themselves offside. In order to address that, it's based on averages over several years and making sure that, okay, we fell offside, but we've thought about this a few years ahead. We've got some years to plan it. Let's get onside, and let's make sure we stay onside and look at that very seriously. Those are very important things to do and very easy to do well in advance and very hard, if not impossible, to do on the day of. Next, we get into some of the transaction-specific steps. So depending on what you want to do, depending on what your objective is and how the lawyers and accountants have decided to meet those objectives, there are going to be different kinds of steps that need to be taken. So rollovers and freezes, these are very common things that you'll hear about in this type of transaction or in this type of planning. They apply mostly where we're talking about transferring shares onto the kids, where we're talking about locking in value so that we freeze the equity in the parents' hands and pass on future equity growth to the children. Not so much when you're talking about selling it to a third party. Not so much when you're talking about selling it to a key employee. Obviously, lifetime capital gains deduction. For those of you who aren't aware, the Government of Canada permits small business owners who meet certain qualifications, but for the moment, let's say that, if you own a small business and you're engaged in active business, you're not holding on to real estate or something like that, but you're, making goods, you're providing services, and you're Canadian controlled, then at least it needs to be looked into, and you've got, a fairly good chance of qualifying. And, once again, there's more tests to it than that, but the accountants will speak to it, and it's going to change as time goes on. But just north of $800,000 you can receive from the sale of your shares in the company without having to pay capital gains tax on it. It's a big benefit. The tax savings on it are, in the ballpark of $250,000, depending on, what your tax brackets are and all that, and what your, tax picture looks like otherwise. And it's just a matter of qualifying or not qualifying. And, if you find that, gee, I wish we'd thought about this 2 years before, so we could have brought the company into compliance, but as it is now, I'm not going to qualify and I have to do the transaction. Well, you might have cost yourself $250,000, and that's not a nice situation to be in. Family trusts are also something that may come up as part of this process. There have been a lot of changes with the federal tax code, and the family trust is being targeted as something that's not really desirable in the eyes of the federal Liberals. I understand why they've got an issue with it. They've proposed some changes. They've backed away from some of the changes. But, I think the winds are still blowing here, and it could be that in a few years from now, we're looking at a different landscape when it comes to family trusts. And I think a lot of people are still trying to come to grips with what the changes so far mean in terms of using these things as strategies. They were very, very popular a few years ago, and they've fallen out a bit since, and I think part of it is the worry about what might happen. But one of the things these family trusts has generally allowed people to do is combine their lifetime capital gains exemptions with other family members. And so if you're selling your business for, $3 million and you got 4 family members that are, divvying it up between them in the family trust, there's a lot of tax savings that they can do through that. Now, there are consequences as well, and it's very important the accountants weigh in, and it might not be appropriate in all circumstances. But when we're talking about sales of business to third parties, often people will start thinking about family trust. And if it's important for you in your transaction, in your specific transaction, it can make a big difference. The last transaction-specific step is unanimous shareholders agreements. Now, again, these aren't going to come into play with the sale to a third party. These are going to be much more important when we're talking about a slow transition of power or a transition of power onto children. So a unanimous shareholders agreement is really just a contract between all the shareholders of the corporation and the corporation saying, this is how we are all agreeing that this company is going to be run, and this is what we are agreeing the rights and obligations and duties of shareholders, directors, and the corporation are to each other. Now, a lot of people have a 10-page unanimous shareholders agreement from the 1980s that's been sitting in a drawer gathering dust, and they've never looked at it, and they don't think it's very valuable. Right now, my precedent for these things is about 60 pages long. They're big. They often sit in drawers still. I'm happy when they sit in a drawer. Just because it sat in a drawer and hasn't been used doesn't mean it wasn't important. Doesn't mean just the knowledge of that thing existing stopped disputes from even arising. And when it is important, when it does, save the day, when, one line of that 60-page document becomes important, the entire thing's worth its weight in gold. And it's the difference, between businesses falling apart and businesses surviving. So I'm a big proponent of them. And when it comes to a transition plan where you say, well, gee, I've got 2 kids, say, and they don't get along with each other so well, and I want to transition the business out to the 2 of them, here's your opportunity to make a contract and say, here's how you 2 are going to behave in relation to one another, and here's how you 2 are going to run the business. And if anyone has any problems with that, you've got a contractual right to enforce it later on. So really, really great tool for something like that. But of course, if a third party is stepping in to buy your business, you don't care so much what they do with it, and they're not going to agree to some kind of USA. But sometimes you have residual shares in the company. Sometimes you're not fully divesting yourself. Sometimes you're going to be on for 10 years and you're going to get bought out 10% a year through that process. Unanimous shareholders agreement. Make sure you're treated fairly through the process. Make sure that your equity in the company is being protected as that happens. Make sure that, if this person wants to make just a disastrous business decision, you've got some ability to stop them from doing that. Step 5, other matters. As a necessary consequence to a lot of this work and selling a business and getting just a ton of money or a ton of new obligations and responsibilities, wills are going to become important, and giving some thought to estate planning is going to become important. So there's a very common strategy right now. Personal corporate wills, some people call it probate, non-probate wills, some people call it a primary, secondary will. Basically what it is instead of having one will where all of your assets are, listed and gifts are made, if you were to pass away with that, all of your assets would be subject to a 1.5% tax. It's called probate. Assuming that any of your assets had to be probated, which, assuming you own a family home or something like that, probably will happen. So you lose 1.5%. On the other hand, there's a strategy to have 2 wills One dealing with the assets that must go through probate and you must pay the 1.5% on, and the second will dealing with the shares of the corporation, which don't necessarily have to go through probate. And if you've got that second will that doesn't get probated, you get to save the 1.5%. It's a big tax savings. Again, there's this question of how long this is going to be around for, but it's something that a lot of people, a lot of business owners with a company that's worth, worth enough to pay for the cost of doing this will absolutely take advantage of. The estate planning question, why this ties in so well with wills, is if you're saying, well, okay, look, I'm getting a few $1 million from the sale of this company, and I don't want to tuck it away into a family trust. I want to have that in my pocket. And then you say, well, okay, and the business owner's 80 years old. What are the plans for when he passes away? Is the plan, I'm going to sit on a beach and I'm going to spend all of my money and that's it, and there'll be a few $1,000s left over to the kids? Or is the plan something along the lines of, no, I'm going to live the lifestyle I lived when I was still working. I'm not going to be, spending terrible amounts of money. There's going to be a lot left over for the kids. Well, why are we doing it this way? Shouldn't we be looking more at a family trust or something like that? So they flow together very nicely, and the sale of the business is a really good opportunity to put that money into the place we want it to be for estate planning purposes, to help minimize tax on death, to help minimize probate fees on death, all that. The last 2 points tie together a little bit, but liability exposure and business risk exposure. As small business owners, you're probably used to taking on a fair amount of personal risk. There are personal guarantees to be given on credit facilities, on leases, all sorts of things. If the business goes, it's understood that there's going to be a personal impact to this. That's just kind of the cost of doing business. You take on those risks. That's not necessarily the case once you've transitioned away. And a lot of the transition planning is about thinking about, well, what are the residual risks going to be, both business risk exposure and personal liability? Is this a time where we should be thinking about strategies to shield personal assets from creditors, such as family trusts? On the business risk exposure side, one of the fairly common things I see is payout times on sales of business. So you're selling the business, but the purchaser doesn't have all the money to buy it right away. They need a few years. There's going to be 4 or 5 years of lead time where you're getting paid out 20% a year, 25% a year, something like that. And there's a question, well, hold on, who is responsible for business risks during this time? Are you still on the lease for the business, even though you've really sold the company and someone else is the shot caller here? If they make bad decisions, how do you make sure you get your share of the money? And why is it that if the bank lends you $1 million, the bank secured 5 ways from Sunday, but if you're lending a purchaser $1 million, you're not secured at all. And in fact, your payment is subject to the business doing as well as they hoped it would. So these are all things to consider. There are some strategies to dealing with it. They're good conversations for the lawyers, accountants, and owners to have during the introductory phase, but it's always something that should be on people's minds. So, common problems. Every overall objective, every different thing that might happen is going to have different kinds of problems that can arise. So if you're selling the business to a third party, there's going to be due diligence. The purchaser needs to make sure that they're actually getting what they think they're getting. The due diligence process can be painful. It's not like much of the other things that business owners have done. They're bombarded with document requests. They've got to, keep track of a huge amount of stuff. I think the due diligence checklist that I use has, north of 100 questions on it. Things like what are your patents? What are your trademarks? Do you have any, are there any claims made against you? And if so, provide me a copy of the statement of claims and details about where the lawsuit is. Most of the time we ask those questions so that the answer is no. However, a surprising number of businesses of a surprising number of sizes answer yes to a lot of those questions. And it has to be gotten into. Another common problem, if we're talking about passing the company on to kids, well, do the kids get along? And I raised this point before, but it's worth doing again. Is the parent who owns the business the arbiter between the kids and the force keeping them on the same page? And without that force, are the kids going to be able to run this business together well? Do you have one kid who's, a brilliant business person and another kid who's just kind of there for a paycheck and, working at mom or dad's company, and that's what they're doing? The kid who's a brilliant business person, they might not feel it's particularly fair for half of their, brilliant business decisions and building up the equity of the business to go into the hands of the child who's not really contributing just by, virtue of their birth. Another common issue, owners who hold on too long to their companies. If the plan, and it's not an uncommon plan, but if the plan is, I'm going to work until I die, generally what that means is we're planning for, one day the owner to just disappear and no one really have a firm hand on the reins of the ship. That's planning for a problem. Also, it's easy for businesses to get stuck in doing things their own ways, and bringing in the young blood, bringing in the kids, bringing in the new hire is going to allow the company to innovate and stay viable. It's one of the unfortunate things, but I've seen companies tend to wilt on the branch a little bit as things go on past owners in their 80s. And it's just a personal matter. Whenever someone feels like it's time for them to step back, they need to think about, well, how is the transition going to work, and how do I make sure the business stays, fresh and bouncing with who is ever going to be taking over. Next point, no way out zombie shareholders. This isn't a nice name for the shareholders. I guess, I don't terribly mind calling them zombies, but I don't mean it in a terribly derogatory way. It's just very descriptive of what's happening. A common arrangement is for someone to provide the financing and someone else to provide the sweat. And that works very well for, two people going into business together. And, the one guy's going to advance $500,000 and the other guy's going to work. And it goes on for 20 years. They're very happy. They make a lot of money together. They've had a great relationship. But now they start thinking transition planning. The guy who did the work, he's thinking to himself, you know what, my son wants to take over. It's going to go really well. The guy who lent the money thinks to himself, you know what, I've been getting these sweet dividend checks. It's been very good over the years. I want to pass on those shares to my daughter so she can receive. And the person who's, looking at taking over could be saying to himself, well, wait a second, my parent has been paying this person, half of the money from this business for decades now, and that's all well and good. But if I'm going to start working for it, I want to own the company. I want to own all of the equity here. I don't want half of my labors to be going to someone I don't know at all. The child of this business partner, I've never even met them. I've met the business partner like 3 times. That's a problem. It can mean that your succession plan doesn't work because the person you want to take over isn't willing to do it on the terms that you can offer them. Now, there are ways to deal with this, but one of the things we can't do is just force the other person to sell, absent a unanimous shareholders agreement, absent some other kind of custom and rare situations. But if I own shares of a company, barring something in law or in contract saying I have to give those shares up in a certain circumstance, well, you can't just take them away from me because you feel I got mine, right? If I own shares of Ford can't pull my shares back just because they don't, feel I deserve my dividends. Another common problem, you want to pass on the business to two kids. One's interested, one's disinterested. I guess I've probably talked about this a fair bit so far, but it's worth mentioning because it happens a fair bit. Finally, timing problems. I've mentioned this already, but again, it really bears repeating. Capital gains exemption and the purity test for it. The assets of the corporation have to be of the right kind and used in the right kind of way for enough time, and the shares of the corporation have to be owned by the right people for long enough. And both of those tests are over years. I don't want to quote a number. It's for the accountants to do that, but it's over years, and it's a big tax savings to qualify and take advantage of this. So, raise it with the accountant right away. Have a plan to bring yourself into compliance, and if you can wait the time, fantastic. And a lot of people qualify anyways. It's just a shame when, someone comes in and you're saying, well, gee, if only we had known that you wanted to do this a few years ago, we could have gotten you into a place where you could take advantage of this. Another thing I mentioned, the federal tax changes. No one knows how long the capital gains exemption is going to be around for. No one knows how long the family trust pooling ability is going to be around for. No one knows how long the probate, non-probate will structure is going to be around for. It's an active concern, and it's something that, if you've got the ability to take advantage of the lifetime capital gains exemption in the short term, it should be a discussion with the accountant as to whether, now is the time to do that, or you're going to wait for, 2, 3, 5, 10 years. My last point is a simple share transaction, and this is kind of an example one. A lot of the time when people call me to discuss these things, they say, "Oh, it's very simple. I'm taking my shares. I'm selling to these guys. It's very simple. Everyone's on board. Everyone's fine." When you don't do the planning in advance, like in my example, we start discovering as the transaction is ongoing that these companies are much more complicated than they first appeared to be, that there are all sorts of credit facilities and guarantees in place that need to be dealt with. And, you start talking to the client and you say, listen, we gotta deal with these. And no, just get it closed. We'll deal with all of that post-closing. I'm okay with that. All right, it happens, but I've got that file sitting on my desk now. We're over a year later. We're still trying to get those things. And, no one feels any great rush about it because, we've already, quote unquote, done the deal. But meanwhile, these things are still floating out there unresolved, and they're an issue for both buyer and seller that these things haven't been dealt with. That is my presentation. Are there any questions? I see that we've got some chat questions. Oh, no. If anyone has any questions, you can type them in the chat. We'll deal with them as best we can. Oh, Chris is just letting us know her phone isn't working at the moment, so we've got a little bit of a tech issue there. We'll try to get sorted out. As we wait for that to get resolved, if in the next days or weeks you have a question about something we've talked about, or just a question about this in general, I'm always happy to speak with people on the phone, have a quick conversation without sending out a bill on it. But please feel free to get in touch. Always happy to answer those kinds of questions.
Sorry about that. Can you hear me now?
Oh, I can hear you.
Yeah, sorry about that. I'm not sure what happened. Okay, I'm just going to go through these two questions here. Have you touched on those yet?
I don't believe so.
Okay, perfect. Okay, first question. What is the shortest amount of time needed to put some kind of transition into place?
Okay. So the answer to that is it's going to depend a great deal on the business and the complexity of the business and the complexity of what they're doing. It's also going to depend on where the business is. So people, come to me and say, oh, gee, can you get it done for the end of February? And the answer to that is, well, I've got the ability to do the things that I'd have to do to get this done, in a fairly short period of time. But there are a lot of steps that have to be taken by the owners, by the accountants, to get things ready for me to do the work I have to do. So, as much as I've seen transactions that happen quickly, they never happen as quickly as the business owners would like, and planning in advance would very much help speed up the process. If things have been planned in advance and we know what we're doing, we can generally do them relatively quickly. But still, it's generally a process that takes months, not weeks.
Perfect. And just one more question. Is there a certain kind of accountant who does this type of work?
So on the accountant front, I feel fairly strongly that accountants should be sitting down and having conversations with business owners on an annual or every other year kind of basis to understand where the business is, what's happening with it, what are the owners' long-term plans, those kinds of things. And if an accountant is doing those kinds of things, I think they're generally the right kind of accountant to have these conversations with. Any accountant is going to be able to assist with the tax planning for a transition plan, as far as I know. I mean, they might have different regulatory hurdles they've got to go over, but it's the interest in a client's business. It's being careful about what it is they want, thinking about their long-term plans, and turning your mind to what's going to be happening not in this tax year, but in 5 tax years from now, that I really look for, and I try to give to my clients as well. I think it's the mark of a good lawyer.
Perfect, Nathan. Thank you very much for your great presentation. We really appreciate it. I'm just going to go through a couple upcoming events for the Chamber. We have Milton Young Professionals, February 20th, Mayor with the Breakfast on the 22nd, our regular business after hours on February 26th at Enable Education, and a special event on March 7th, Ensuring Success for Women in Business. Thank you, everyone, for attending, and have a great day despite the weather.